The DF, you recollect, in one of its bills it proposed to the country, we had wanted the Electoral Commission to go ahead and make provision for the diaspora and the prisoners to vote. You're also aware that the matter of diaspora voting and prisoner voting was litigated upon in the High Court of Uganda, and Justice Lydia Mugambe, in her orders, initially in the declaration of court, she said that it's unconstitutional to deny the diaspora and the prisoners from voting. She actually ordered the Electoral Commission to, in the future, go ahead and make provision for them to vote. The last election was supposed to be the first to follow up that order. It was not done. So we are inviting the Constitutional Court to again make declaration and order again the Electoral Commission. First of all, to again declare their actions as unconstitutional, reaffirm what the High Court declared, because we believe that you cannot disenfranchise more than 3 million citizens from voting, and then you say you're executing your constitutional duty. We would like court to consider this as a very serious delegation of duty by the Electoral Commission to ignore over 3 million citizens from voting by not making provision as a matter that is unconstitutional, and therefore particular orders be made. And 9, you are aware that the Constitution makes provision for individuals that cross parties in the 4th year in Parliament. Various parties, various members of Parliament, to bring you to speed, the DF has 5 members of Parliament that belonged to other political parties hitherto. When they crossed from their previous parties to new party, that party must, as of law, become a parliamentary party. The Electoral Commission does not construe the DF, probably, and the PFF as parliamentary parties, and therefore it does not treat them or deal with them as parliamentary parties. We believe their conduct is unconstitutional, and we are inviting the Constitutional Court to agree with us that their actions, their treatment of the DF and other parties that have members of Parliament having crossed over from other parties as unconstitutional, and therefore make particular orders and declarations. So, don't the court to give us guidance on how and when to proceed. Notices have been served to the Electoral Commission and the Attorney General on the filing of this particular petition by the DF as a party, and the particular members of the DF that have deponed affidavits will be there on their own behalf and on behalf of the party as petitioners. But like I said, the Secretary General will share with you the entirety of the petition so that you'll be able to share with the country. That the DF is considering a number of options after the botched general elections that we described as a fiasco. And you remember the DF rejected the outcome of the elections, the entire process, and whatever is and was associated with it. And we informed the country that we would do something about it. And this morning, we are here to inform you that we have filed a petition in the Constitutional Court, asking court to pronounce itself on a number of issues that the DF construes as the reasons why the last election was not an election but a fiasco. And a week ago, we petitioned the Constitutional Court. Notices have been issued to that effect to the stakeholders. We are challenging the various actions of the Electoral Commission by petitioning the court, and the parties are the Electoral Commission and the Attorney General as the law prescribes. And we believe that the Constitutional Court will be able to make particular declarations and pronouncements and orders on the 9 issues, the 9 questions we are asking the court to make particular pronouncements and declarations. And I'm going to enlist them. The Office of the Secretary General and will share with you the entire petition as it is, and so that you are able to share with the nation. That's not a rumor, including sharing with you the notices to the stakeholders. One of the issues we are petitioning is about the failure of the Electoral Commission to demarcate constituencies as per the Constitution. You are aware that under Article 63 through 64 of the Constitution, the Electoral Commission is obligated to demarcate constituencies even after a national population census. The last census was conducted in 2024, and the law mandates the Electoral Commission to use it before the next election to demarcate constituencies by marking out the population quota. The national population quota is 100,000 people. But we know so well that in this country, some constituencies have 10,000 voters or people, others have 100,000, others 500,000, others 1,500. There are those with 3,000 people. So we believe as DF that that was a very big failure of duty, a serious dedication of duty by the Electoral Commission, and it partly accounted for what we saw in the last election. So we'd like the Constitutional Court to pronounce itself on these brazen weaknesses of the Electoral Commission in failing to demarcate constituencies as the law prescribes. Because the law says within 12 months after the census, the Electoral Commission must redemarcate constituencies. What we see is that the Electoral Commission instead supports serious gerrymandering, creating interest-based constituencies, not constituencies as per the law. We believe, as the DF, that this is unconstitutional, and would like the Constitutional Court to pronounce itself on that void. 2, we are aware that the Electoral Commission procured voter verification machines that were used, and in using them, there was no enabling law. We believe that was a very serious void in processes, and because there was no law prescribing so, their usage, their deployment, that's why the Electoral Commission was at liberty to even get away with them and reject their usage in some places and said it didn't function. They malfunctioned. The procurement process had issues because there was no enabling law. Would like the Constitutional Court to make particular pronouncements as to the validity of the usage of the VVR machines. Thirdly, the Electoral Commission purported to be updating the voters register. The register, as you're aware, was constructed at various stages using methods that were not very clear to the actors. The actors are the population, the political parties, civil society, and all stakeholders. Up to now, there's no clarity as to how the Electoral Commission came up with the register they used in the last election. And in the process, we believe that greatly compromised the integrity of the entire electoral process. Because the electoral process is as good as the integrity of the processes, as good as the integrity of the register that is deployed to validate the election. Fourth, you are aware that for every presidential candidate, the Electoral Commission requires that you must get 100 signatures from 2/3 of the districts in the country. At the DF, we believe that that is unconstitutional. What the Electoral Commission says is that in collecting signatures from every district, 100 signatures, the candidate is a candidate, becomes a national, has a national outlook. But for a candidate sponsored by a political party, for you to register a political party, it must exhibit a national outlook. So for you to again require their candidate to again collect 100 signatures in every district, 2/3 of the districts, you are making them do double work. It's unconstitutional. We believe that the whole idea of signatures must be for independent candidates, not candidates sponsored by political parties. We're challenging that, believe it wastes parties' resources, it wastes candidates' energy, because already if you're a political party, you're registered by the same Electoral Commission because you've exhibited that you are a party of national character. You don't have to do that again. So we would like the court, National Court, to pronounce itself on the validity of that act, which we believe is an act in West and therefore duplicating work already done. 5, we all see the brazen interference of the military, to be particularly the UPDF and its attendant organs, interfering and making pronouncements of various nature that scattered the country and disoriented voters. This has been the case, and the UPDF continues in a particular way to interfere with the national elections. And this interference has compromised variously the independence of the Electoral Commission as supposed to be. So we are inviting the Constitutional Court to make a pronouncement on the continued interference, illegal interference of the UPDF, and the particular pronouncements made by the UPDF, in particular its commanders and officers at various stages, that we believe is unconstitutional and therefore has only served the purpose of causing disorientation and, in a way, disenfranchising the process and the voters. 6, the law requires that the Electoral Commission should tally presidential election outcomes at the National Tally Center, including parliamentary election results at the district tally centers. But as we know it, the Electoral Commission announced presidential election results without anything from the National Tally Center. We are questioning announcements from wherever they were, without recourse to the law, without doing what the law requires them to do. We are inviting the Constitutional Court to declare their actions unconstitutional and therefore make particular orders and declarations. 7, the Electoral Commission, in particular the district returning officers, did not electronically avail presidential election results to presidential candidates' agents, to observers. I'm sure even the media never saw the results at the districts before they were transmitted to the National Tally Center. In other words, majority of the district returning officers simply transmitted what they were ordered to transmit. They never shared with anybody. Up to now, nobody knows what they shared at the National Tally Center. We regard their actions as unconstitutional, and they served to render the entire exercise null and void. We are inviting the Constitutional Court to declare their conduct unconstitutional and outside the realm of the legal requirement. 8, I want to share with you and the nation this morning. The second issue relates to the Protection of Sovereignty Bill 2026. You are aware that a lot of sections of society have shared their views on this controversial bill. As a lawyer and as a leader and a citizen, I am aware, as well as my colleagues here, that the purpose of legislation is to solve serious or underlying particular society problems. In as far as this bill is concerned, the DF believes that the bill in its entirety is null and void, and there's no amount of cleansing that can change its evil intentions. And therefore, the DF has ordered its 5 members of parliament to reject this bill in its entirety, and we do not want to associate with its intentions. If you follow Parliament, you are aware that about a year and a half ago, Parliament, in a single day, amended over 11 existing laws, acts of Parliament, including but not limited to the Anti-Money Laundering Act. We also amended the Anti-Terrorism Act to particularly take care of matters relating to illicit financial flows into the country. Because we are advised that if we don't do those amendments in haste, our financial systems will be closed from international transactions. And we did that about 1.5 years ago. Now, for anybody to return again to do the same job, but in particular, we are aware that the government is interested just in about 2 or 3 clauses from this bill. And therefore, they are hiding behind this to achieve the whole idea of extending the sell-by date of the NRM government. If the NRM wants to extend the sell-by date, you do not do by legislation. You do that by evolving pragmatic people-based programs, not by legislation. So we are inviting Parliament, to which I am a part, to rise to the occasion and say, please, we have better things to do. And as the DF, on some of the issues herein, we have indicated. For instance, the targeting of diaspora citizens is a matter the DF had wanted to overcome by involving diaspora citizens into civic activities of the country. If they were voters, there's no way you will come up with legislation targeting them. So we'd like to invite the diaspora to always be alert, desisting from excitement, and clearly understand what matters in this country. Now that this law is partly targeting diaspora, they must understand that part of the insurance they need is to be directly involved in the nation's civic activities, including voting. So the DF is ahead of time. We shall continue to pursue what we had advised the nation to do, and I think people never paid attention. So now that the chickens have come home, we invite again the citizenry to pay attention when leaders make mention of particular pertinent issues that might affect them today and in the years ahead. So we are informing the country that the DF believes that in a nation that we are, that is a melting pot of ideologies, culture, religious, we don't have to do anti-people legislation. And the NRM must understand the whole idea of legislating across partisan lines. So if you do not understand what it means to do legislation that is bipartisan, this is a bipartisan bill. This is a partisan bill. It cannot pass the test of a bipartisan bill. That's why many citizens and agencies, private, public, civil society are rejecting it. Because when people hold it, they don't know themselves in that bill. It's entirely a single party bill. We want to invite the NRM that after 40 years in power, you must be thinking of tabling bipartisan legislations. Not legislations that disenfranchise and make the NRM a superior entity and other actors in public space to look as though they are alien. So the bill fails the critical test of a pro-people bill, and therefore the DF rejects its entirety. The third issue we'd like to bring to your attention is an issue that is playing out in public space back and forth. It has to do with the trade order to which government. We have this to say. First of all, everybody likes order. But society order begins with governance order. A government that is disorganized cannot organize society. Why did the government have to start with a trade order before making provision for workspaces and new markets? Now that the order is in place, at the DF we are saying, the government must come out and inform the affected people. When are they making provision for community workspaces where people will go and make a livelihood? I have been studying the budget for the Ministry of Local Government for the next financial year. There is no provision. I've not seen a vote, a subvention where there will be provision for community workspaces and new markets. I've not seen it. So may we see order starting from governance? Because seemingly there is governance disorder. If government is organized, the citizens will equally be organized. The existing trade disorder, the citizens are following the way government runs. So everybody is issuing orders. RDCs, ministers, witch doctors, everybody is issuing orders on behalf of government. So the citizens are asking, so which orders should we follow? Orders are issued, they are withdrawn, and then reinstated. So we need governance order. The minister must show that is actually ready to accommodate people that have been disoriented by the trade order. We would expect now that the Ministry of Local Government, through which these orders are being pursued, to indicate with clarity, no vagueness, in each community, where they are going to organize community workspaces like it's done in other organized communities and organized governments. Otherwise, we want to see order, but the governance order first, formed by clear guidelines in local governments, where trade will be carried out in an organized way and government will be in charge. Relatedly, we expect the minister to follow up with people that were given open license to confiscate properties of the poor people and eventually store them in the guise of trade order to return them to the owners. We don't expect that they have power to steal from the poor in the name of the trade order. Government, the ministry in particular, to return stolen property to the poor people. And where it was destroyed unreasonably, the poor must be compensated. We don't expect them to return where they're working from, but they must be organized and assisted to work. It's the duty of government to ensure that people work. It's the duty of government to ensure that people have jobs. So if in their own initiative, people have created their small survival jobs, it's the duty of every serious government to protect them and ensure that their livelihoods are not destroyed or scattered. So at the DF, we thought that those are very serious national issues to which we should invite you to share our stand with the nation. I want to thank you.
Fellow Ugandans, the Uganda Communications Commission would like to address you regarding the responsible use of communication platforms in light of the recent developments. We are aware of the Constitutional Court decision that annulled certain provisions of the Computer Misuse Amendment Act 2022. Following this ruling, there have been reports of increased misuse of social media and other digital platforms. Some users appear to have been misled into believing that there is currently no other law governing the use of computer systems in Uganda. We wish, therefore, to clarify that this is not the case. While the court annulled specific sections of the law, such as those relating to unauthorized access, hate speech, unsolicited and malicious information, and misuse of social media, many other provisions of the Computer Misuse Act remain fully in force. As a matter of emphasis, we would like to emphasize that the annulment of those said sections of the Computer Misuse Amendment Act 2022 obviously does not sanction or condone such behavior or misuse of computer platforms. Hate speech, unsolicited and malicious information, misuse of social media is still morally, ethically, and legally unacceptable behavior that can be prosecuted under other existing laws on cyber harassment, cyber stalking, electronic fraud, and other such related laws. Similarly, although certain provisions on libel under the Penal Code were annulled, the rest of the Penal Code Act remains applicable. In addition, other laws, including the Uganda Communications Act, the Data Protection and Privacy Act, and the Children's Act, continue to regulate the use of communication platforms and protect the rights of individuals. We therefore urge all users to exercise responsibility in their use of digital platforms. Let us use technology to advance our socio-economic well-being and not to harm others, violate their rights, or undermine peace and security of our country. We also encourage the public to report any misuse of communication platforms to the Uganda Communications Commission or the Uganda Police Force. Let us all play our part in ensuring a safe, respectful, and secure digital environment for everybody. I thank you.